Hello and welcome to this third video on federalism. I am Ms. Jennifer Blank and I will be your guide on this journey. Today we are focusing on how government power works in federalism. But before we do that, I want to just take a quick quick look at what we talked about in the last video lesson, right? So part one, we looked at key vocab, we looked at the definition of federalism, then we looked at different systems of government and how federalism is different from those other systems. Part two, we discussed the different types of federalism, and now we're going to have a discussion about how government power works in federalism. So this video lesson is going to be a little judicial branch heavy because we want to look at vertical checks and balances. All right, we've examined the three branches of government and seen how they check and balance each other, but the beauty of federalism is that there are multiple checks and balances. Sorry, my cat is trying to do things outside the camera. So we want to take a closer look at those cases. So without further ado, let's get started. So here are some definitions of federalism. Personally, I prefer the second one, division of power between a national government and several state governments. The reason that I prefer this one is because it emphasizes this division of power. When our founders were creating our system of government, they were hyper-focused on preventing concentration of power. Wherever you have concentration of power, you have corruption. It is guaranteed. It is inescapable. It never ceases to happen, okay? So in order to try to limit the corruption as much as possible, they wanted to make sure that power was never concentrated. Not only did they prevent that from happening by having three branches, they also prevented it from happening via power in the national government and power also in the state governments, right? So we have the horizontal checks and balances, and through federalism, we have vertical checks and balances. So, pardon me. Max, behave. Okay, so key vocab, you need to commit this to memory. If you haven't memorized this already, please do with all deliberate speed, okay? Delegated powers, reserved powers, concurrent powers, prohibited powers. Make sure you write this down. Make sure you memorize it. It's going to be on the exam. All right, so our first case that we're going to discuss is arguably the most important Supreme Court case of all, and that, folks, is Marbury v. Madison in 1803. Now, why do we care so much? Because this Supreme Court case established judicial review, the core power of the judicial branch, and also its ability to check and balance the other two branches. So this case is really, really important. So let me give you some background. So the election of 1800 was a hotly contested election. It was very significant because it represented the first peaceful transfer of power in the history of the new nation, which doesn't seem like a big deal, I guess, but we have the benefit of several hundred years of peaceful transfers of power, 2020 notwithstanding. But this one proved that the American system of government could actually work. So you have Adams of the Federalists versus Jefferson of the Democratic Republicans. Now, Jefferson wins, but then the issue that will present itself in Marbury v. Madison quickly becomes apparent. Once Adams realized that he lost, you also have to keep in mind that the Federalists had just lost control of both two branches of government, of the executive and the legislative. So at this point, Adams and the Federalists are desperate to maintain power over at least one other branch. So what does he do? The second before, a few hours before he's set to leave office, he makes these last-minute judicial appointments. These are known as midnight judges, okay? So now, the midnight judges were known as that because they were signed in at the last minute, many in the wee hours of the morning. Literally, Adams was signing appointments as he's vacating the Oval Office, right? So Jefferson comes in, and as president, he selected Madison to be his Secretary of State. Now, the Secretary of State is actually charged. That's their job, to deliver federal appointments, right? So Madison says, dude, Jefferson, what do you want me to do, Mr. President? And Jefferson says, the Federalists are out of office. Whatever appointments didn't get delivered, they're not getting delivered. Forget it. Don't even worry about it. So he's like, all right, cool. I just won't deliver them. Marbury, however, this guy, William Marbury, finds out that he was supposed to get an appointment, didn't get it. And he's like, that sucks. I'm not here for that. So he's going to sue Madison because technically it's Madison's job to deliver the appointment. Hence, Marbury v. Madison. He sues to get his appointment. So what happens? Well, the verdict is Marbury doesn't get to take the bench. Why? Because the law that actually made his job that he's trying to get was declared unconstitutional by the Supreme Court, therefore nullifying the existence of the position, so he doesn't get it. He was not happy about this, but hey, what are you going to do? So this is the first time that the Supreme Court overturns an act of Congress. The first time it actually exercises its constitutional authority and its check and balance power. So this is checks and balances in action, folks, in action. And you need to memorize this definition too. Judicial review, Supreme Court's ability to declare a law or act unconstitutional. Very important, very important. Going to be on the exam. Excuse me. Now that we've gotten that first case out of the way, that was an important foundation for what the rest of what we're going to talk about tonight. We need to start looking at cases that directly involve federalism. One such case was McCulloch v. Maryland in 1819. And there's a little description there. It affirmed that the power of Congress is not strictly limited to the expressed powers, to the enumerated powers. Marshall, the Chief Justice at the time, held that Congress has implied powers to carry out the expressed powers. So let's talk about the facts of this case a little more in detail. So in order for the federal government to follow through on its duties of coining money, right, and controlling currency and regulating trade, things of that nature, they needed to have a national bank to handle all those transactions. So there was a branch of the Bank of the United States that was operating in Maryland. Now, Maryland, being a very, states' right state, was like, no, I'm not here for this. I don't want competition for my local banks, my state banks, my regional banks. Get out of here. We're going to tax the heck out of you to put you out of business. So McCulloch, who was a Bank of U.S. employee, he's like, I'm not paying this tax. You don't have the authority to tax me. I'm from the national government, dude. You don't, no, I'm not doing it, not paying it. So, of course, a lawsuit ensues, right? So is the Bank of the United States constitutional? Absolutely. Yes, it is. The national government has these implied powers that go beyond the delegated because we need a national bank, like I said, borrowing, lending, holding minted money, all of which are delegated powers. But you need the national bank to help exercise those delegated powers. So this massively increases the power and authority of the federal government at the expense of the states. So John Marshall has reaffirmed the Supremacy Clause and the Elastic Clause. The federal government is supreme. The state cannot tax the federal government. So there you go. So there's one example of federalism in the courts, of federalism in action. Now another case, also fun, Gibbons v. Ogden. This was in 1824. So what this case did was it allowed the national government to regulate, at this point, virtually all economic activities. Not all, but almost all. And so let's talk about the situation, how this case arose in the first place. So before we get to that, let's talk about the Commerce Clause. The Congress shall have power to regulate commerce with foreign nations and among the several states and with Indian tribes. So Congress, over the course of our country's history, has used the Elastic Clause to stretch this power significantly. Commerce, simply put, is the buying and selling of goods and services, virtually any economic activity, really. So Congress is given the power to regulate commerce between foreign countries and the U.S., and in between states, not within a state, but between two different states. Okay, not within a state, though. So Gibbons v. Ogden, 1824, its nickname is the Steamboat Case because this dude Ogden, he received a state-licensed monopoly. He was the only guy allowed to run a ferry across the Hudson River, which incidentally crosses the Hudson River, involves two states, right? New York and New Jersey. So Gibbons now saw this potential of traffic between New York and New Jersey. He obtained a federal license. So Ogden sued, saying, listen, I have a valid state license, okay, and I get a monopoly. So your U.S. license doesn't matter. So they went to court. Gibbons won. Gibbons won because what happens? Interstate commerce. If you're ferrying people for money across state lines, guess what? That's interstate commerce. That's between the states, not within a state. Therefore, Ogden's little monopoly license was null and void. Gibbons' license takes precedence. So as a result of this case, federal government gets stronger, and the federal government has definitely used this authority to regulate virtually every aspect of the economy. And this is something we'll get into in more detail when we get into the three branches, also when we get into public policy. So the Commerce Clause, why do we care? Why is it important? And this, I pretty much covered this in the previous slide, but this makes a loophole for Congress. They can take control over anything involving the movement of people or things between states or between the United States and somewhere else. The power of the federal government is massively increased here. So the necessary and proper clause is important. I want to revisit this. The Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Now, the founders were smart enough to realize that it was impossible to predict the precise powers that Congress would need in order to fulfill its necessary duties. So they wanted something in there that allowed for some mobility, but they also left in methods to check the federal government. And we'll talk more about that when we get into the three branches. So the final case we're going to discuss today is United States v. Lopez in 1995. Now, this is an example of the federal government taking the Commerce Clause to such a ridiculous conclusion that the Supreme Court said, just slap them right down, forget it. So in 1995, a gun-free school zone law banned the possession of firearms within 1,000 feet of a school on the basis of the Commerce Clause. Okay, that was their justification. They said, we have this authority because of the Commerce Clause. But the law was declared unconstitutional because this law has nothing to do with commerce. These people want to regulate guns, which is all fine, well, and good. But here's a little hiccup. We have this thing called the Second Amendment that guarantees this right. It identifies the right to bear arms as a fundamental right. So if you're going to limit it, you had better have a much more robust constitutional justification than a ridiculous stretching of the Commerce Clause. So this is an example of a court case that massively limited national government power. But this is where we had some conflict, mostly because of the Second Amendment, much stronger than the justification of the Commerce Clause in this situation. So I want to remind you before we go about this. Interstate relations is going to be a key factor in terms of understanding federalism. So you're going to want to make sure that you understand that Article 4 of the Constitution contains all of these clauses. If you're forgetting what these clauses are, I invite you to rewatch and take notes on my Important Clauses of the Constitution video lesson, where I discuss each of these clauses in detail. So definitely make sure to go back and check that out, but you must know what these clauses are, and you should know that they are in Article 4. And that, folks, is the end of our video series on federalism. I hope you learned what you needed to, and I will see you in the next video.